The state has a plan for your house the moment a doctor writes the word dementia in your medical file, and that plan ends with a lien on your front door, not a rumor, not a worst-case scenario, a legal process operating in all 50 states, funded by the federal government, executed by state Medicaid agencies with the full authority of the Social Security Act behind them. It is called the Medicaid Estate Recovery Program. It was built to collect. It has been collecting for 30 years, and the reason most families don't know it exists is the same reason most traps are effective. It operates in silence, in the background, while your attention is entirely consumed by the emergency in front of you. Helen Burroughs is 76 years old. She lives in a Cape Cod on the north side of Richmond, Virginia, the house she and her late husband Walter bought in 1981 for $67,000. Walter died in 2017. Helen has lived there alone for 7 years, maintaining the garden Walter planted, keeping the bird feeders full, walking the same 3-block loop every morning with a cup of coffee in her hand. Her daughter Carol, who lives 40 minutes away in Chesterfield County, calls every Sunday. They are close. Helen is independent, sharp, deliberate. She has $310,000 in a traditional IRA, $44,000 in a savings account, and a house that Zillow estimates at $387,000. In September 2024, Carol notices that her mother has asked the same question 3 times during a single phone call. In November, Helen leaves the stove on twice. In February 2025, a neurologist at VCU Medical Center administers a full cognitive assessment. The diagnosis: moderate Alzheimer's dementia, with an expected progression to severe within 18 to 30 months. Helen cannot live alone. She cannot safely manage her finances. Carol applies for power of attorney, but Helen's capacity is now legally questionable, which means the power of attorney executed in 2019 is the operative document, if it was drafted correctly, if it covers what Carol needs it to cover, and if the IRA custodian and the bank will honor it. Carol does not know if any of those conditions are true. She has never read the document. Helen moves to a memory care facility in April 2025. Monthly cost in the Richmond metro area, $6,400 for a semi-private room. Helen's IRA and savings account, $354,000 combined, will fund private pay for approximately 55 months, 4.5 years. Helen is 77 now. She may live to 85. She may live to 90. The actuarial tables for women with moderate Alzheimer's at 77 suggest a median survival of 4 to 8 years post-diagnosis. The math is simple and devastating. Helen may outlive her money by 3 years. When she does, Virginia Medicaid takes over the billing. And the moment Virginia Medicaid pays its first dollar for Helen's memory care, the estate recovery clock starts. The lien accrues silently, month by month, dollar by dollar, against Helen's estate. And the primary asset in that estate, the Cape Cod on the north side of Richmond, the house Carol grew up in, the house with Walter's garden in the back, is the first and largest target. Carol will not receive a warning. She will not receive a letter saying the lien is accumulating. She will receive a claim, after Helen dies, from the Virginia Department of Medical Assistance Services for every dollar Virginia spent on Helen's memory care. On a 3-year Medicaid stay at current Virginia nursing facility rates of approximately $8,200 per month, that claim approaches $295,000. On a house worth $387,000 with no mortgage, the state's recovery could consume 76% of the home's value before Carol sees a dollar of inheritance. That is the plan. That is the silence. And if it lands the way it should, if you are sitting there thinking about your own parents, your own home, your own diagnosis waiting in some future neurologist's office, smash that like button right now. Because the countermeasures exist, they are legal, they are documented in federal and state statute, and the only reason most families never use them is that nobody tells them in time. Let's build the damage map, because the MERP line is only one layer of what happens to a home when dementia forces a nursing home placement. There are 4 simultaneous financial mechanisms operating on that house, and understanding all 4 is the only way to understand the full scope of what Carol is walking into. The suits at the agency want me to remind you this is not financial advice. It is a survival guide for an unguarded vault. Talk to a fiduciary elder law attorney before you move a single dollar or sign a single document. Under Social Security Act Section 1917B, every state is required to seek recovery of Medicaid expenditures from the estates of Medicaid recipients who were 55 or older when they received benefits. Virginia implements this through the Department of Medical Assistance Services. The lien does not appear on the property's title while Helen is alive. It is an estate claim, not a property lien in most cases. It does not show up in a title search. Carol will not discover it when she lists the house. She will discover it when the title company contacts her 30 days before closing with a recovery demand from DMAS. The Virginia MERP recovery rate in recent years has averaged between $180,000 and $340,000 per estate for extended nursing home stays. The recovery is not limited to the house. It attaches to the entire probate estate, including bank accounts, investment accounts, and any property that passes through probate. On Helen's estate, if the IRA has been spent down to zero through the private pay period and the savings account is depleted, the house is the only remaining probate asset. DMAS collects against it directly. MERP recovery in most states, including Virginia, operates through the probate estate. If the house passes through probate at Helen's death, it is recoverable. If the house passes outside of probate, through a properly structured trust, a ladybird deed, or a beneficiary deed, it may not be reachable in Virginia, depending on how the instrument is drafted and when it was executed relative to the Medicaid application. This is the architectural vulnerability that most families miss. They assume the house is protected because Helen is alive and living in it. They do not understand that the house's protection status is determined not by whether Helen is living in it, but by how it will transfer at her death, and whether that transfer mechanism routes it through or around the probate estate. In Virginia, the MERP program reaches the probate estate as defined by Virginia Code Section 32.1-325.1. Virginia does not, as of 2026, pursue recovery against assets that pass outside of probate through a properly executed revocable trust or transfer on death deed. This means the choice of transfer mechanism is the single most consequential legal decision in Helen's estate plan, and that decision needed to be made before the dementia diagnosis, before the capacity questions arose, before Carol was managing the situation alone from 40 miles away. Carol has a power of attorney, but Helen's 2019 POA document was drafted by a general practice attorney for $350 as part of a basic estate planning package. Carol has never read it closely. The document uses the word durable, which should mean it survives incapacity, but it does not include specific language authorizing gifting, trust funding, or Medicaid planning transfers. Without explicit gifting authority, Carol cannot transfer the house to a trust. Without explicit Medicaid planning authority, Carol cannot execute a ladybird deed on Helen's behalf. Without explicit authority to make gifts below the annual exclusion amount, Carol cannot restructure Helen's assets at all. This is the capacity trap, the window to act, to restructure Helen's estate, to protect the house, to start the Medicaid look-back clock, closes the moment a court determines Helen lacks legal capacity. After that, Carol needs a court-supervised guardianship or conservatorship to take any significant financial action. In Virginia, that process takes 4 to 8 months and costs $5,000 to $15,000 in legal fees before any protective action can be implemented. Helen's 2019 POA may have closed the protective window before Carol knew the window existed. Helen has $310,000 in a traditional IRA. During the private pay period, the 55 months before Medicaid kicks in, Carol will withdraw from the IRA to fund memory care. Each withdrawal is taxable as ordinary income. At $76,800 per year in withdrawals, 12 months at $6,400, Helen's taxable income reaches approximately $80,000 before the Social Security survivor benefit Carol is also managing. Her marginal federal rate, 22%. Virginia state income tax, 5.75%. Combined, 27.75% on every IRA dollar withdrawn to pay for care. The IRS takes $21,337 out of every $76,800 that goes toward Helen's memory care bill. Over the full 55-month private pay period, the tax cost of IRA distributions alone is approximately $97,000, nearly $100,000 in federal and state income tax paid purely to access money that was already saved and already needed. The tax code does not pause for medical emergencies. Tell me in the comments right now, how old are you this June 2026, And does your estate plan include specific language protecting your home from MERP recovery if you are placed in a nursing home? Yes or no? That answer, in the comments, might be the question your children need to ask their estate attorney this month. Here is the open loop I need you to hold. There is a legal instrument, specific to Virginia and a handful of other states, that can protect Helen's house from MERP recovery even after Medicaid benefits have begun, without a 5-year look-back period, without a trust, without transferring ownership. It is not widely known outside of elder law practice. It does not appear in standard estate planning packages, and it requires that the person signing it still have legal capacity. Hold that. We're almost there. Let's name the architects. Because this system was constructed deliberately, maintained deliberately, and generates revenue deliberately, and the silence around it is not accidental. The Medicaid Estate Recovery Program was mandated by the Omnibus Budget Reconciliation Act of 1993. Every state was required to implement an estate recovery program as a condition of receiving federal Medicaid matching funds. The stated rationale: close the loophole exploited by wealthy families who transferred assets to heirs and then qualified for Medicaid. The actual impact, 3 decades later: a recovery apparatus that operates most aggressively against the middle class, against families with $200,000 to $600,000 in real estate and retirement assets who have meaningful estates but not enough wealth to self-fund extended nursing home care. The dementia diagnosis is the specific trigger that makes the home uniquely vulnerable in ways that other nursing home admissions do not. With a physical injury or a temporary medical condition, the homeowner retains capacity, can execute protective legal instruments, can restructure their estate while the situation develops. Dementia is different. Dementia is a capacity-destroying condition whose onset is gradual enough that most families recognize it slowly and act on it slowly, while the legal window to execute protective instruments narrows and then closes. By the time the family understands that a trust needs to be funded, that a ladybird deed needs to be executed, that the 5-year Medicaid look-back clock needs to start, the person who needs to sign those documents may no longer have the legal capacity to sign them. The dementia diagnosis and the MERP apparatus are not independently designed to work together, but they work together perfectly. Here is the industry that profits from the gap. The memory care facility sector, a $28 billion annual market as of 2026, benefits from the private pay period before Medicaid eligibility. Private pay rates in memory care facilities run 20 to 40% higher than Medicaid reimbursement rates. The longer a resident remains private pay, the more revenue the facility collects. Facilities are not incentivized to help families accelerate Medicaid eligibility. They are not required to tell families about the 5-year look-back, the MERP lien, or the protective instruments that could preserve the estate. The estate planning industry, general practice attorneys who draft basic wills and powers of attorney, typically does not include MERP planning in a standard engagement. The $350 to $800 basic estate plan does not include a ladybird deed, does not fund an irrevocable trust, does not include gifting authority in the power of attorney. The attorney was not negligent. They provided what was requested. The family did not know to request more because they did not know MERP existed. The Virginia Department of Medical Assistance Services collected over $43 million in estate recovery in a single recent fiscal year. Nationally, MERP recovery exceeds $700 million annually. This revenue is built into state Medicaid budget projections. It is counted on. It is relied upon. The states have a structural financial interest in that recovery continuing, which means they have a structural financial interest in families not knowing about the instruments that prevent it. Right now, before this bulletin ends, not after, send this to one adult child whose parent is over 70 and owns a paid-off home, not a parent who has been diagnosed, a parent who is currently healthy. Because the instruments that protect the home require legal capacity to execute, and legal capacity does not announce its departure in advance. Here is the operational playbook. 5 instruments. Each one addresses a different layer of the dementia and MERP trap. Each one requires action while capacity exists. Save this video to a playlist titled Retirement Survival Manual right now. What follows is the architecture that an elder law attorney specializing in Medicaid planning would charge $8,000 to $20,000 to implement for Helen's family, if Helen still had the capacity to execute it. Helen's 2019 POA is the broken foundation under everything Carol is trying to build. The single most important document in a dementia protection plan is not a trust, not a deed, not an annuity. It is a durable power of attorney drafted specifically to authorize Medicaid planning actions, because without it, every other protective instrument requires either the principal's direct signature or a court order. The correct durable POA for Medicaid planning includes, explicitly and by name, authority to make gifts up to the annual exclusion amount and beyond, to fund revocable and irrevocable trusts, to execute deeds including Lady Bird and transfer on death deeds, to apply for Medicaid benefits, to reposition assets for Medicaid compliance, and to engage in Medicaid spend-down planning, including the purchase of Medicaid-compliant annuities. Every one of those authorities must be named. Generic financial management language does not cover them. In Virginia, the statutory durable power of attorney, codified at Virginia Code Section 64.2-1602, allows for the creation of a broad authority POA, but specific Medicaid planning powers are not automatically included in the statutory form. They must be added by explicit language drafted by an attorney who understands both elder law and the Virginia DMAS regulations. The document Helen signed in 2019 almost certainly does not contain that language. If your parent is over 65 and currently has legal capacity, the first call you make after this bulletin is to an elder law attorney to review their existing power of attorney, not to draft a new will, not to discuss the trust, the POA, because without it, every other instrument in this list requires the parent's direct signature, and the dementia progression does not wait for attorney appointments. State nuance. In Florida, the Durable Power of Attorney Act, Chapter 709 of the Florida Statutes, is one of the most detailed in the country and explicitly requires that certain superpowers, including authority to make gifts and fund trusts, be specifically granted rather than implied. A Florida POA that does not explicitly grant those authorities is not sufficient for Medicaid planning, regardless of how broadly it appears to be written. In California, the Probate Code Section 4264 requires similar specificity for gift-giving authority. Generic POAs drafted in any state should be reviewed by an elder law attorney before they are needed. Here is the instrument I told you to hold. Virginia is one of a growing number of states that authorizes a transfer on death deed, also called a beneficiary deed in some states, which allows a homeowner to designate a beneficiary who receives the property automatically at death, outside of probate, without triggering the Medicaid look-back period. Virginia enacted its Transfer on Death Deed Statute, Virginia Code Section 64.2-621 through Section 64.2-639, in 2013. The deed is revocable at any time during the owner's lifetime. The owner retains full control of the property, can sell it, mortgage it, change the beneficiary, until death. At death, the property transfers automatically to the named beneficiary. It does not pass through probate, and because it does not pass through probate, Virginia MERP, which recovers against the probate estate under Virginia Code Section 32.1-325.1, cannot reach it. This is not a loophole. This is the Virginia legislature's explicit decision about the scope of MERP recovery, limited to the probate estate, not to all transfers. A properly executed Virginia TOD deed, signed while Helen had capacity, recording Carol as beneficiary, would have routed the Richmond Cape Cod entirely outside of DMAS's reach. Helen could have remained on Medicaid, the state could have paid for her memory care, and at Helen's death, Carol would have received the house free of any MERP claim, with a stepped-up basis under IRS rules, zero capital gains tax owed on the full appreciation since 1981. That deed would have taken 45 minutes to draft and $200 to record at the Richmond Circuit Court Clerk's office. The cost of not having it, up to $295,000 in MERP recovery. State nuance. The transfer on death deed is currently available in approximately 30 states. It is not available in every state. It is not available in New York, New Jersey, or Kentucky. In states where it is not available, or where MERP recovery extends beyond the probate estate to non-probate transfers, alternative instruments are required. Florida's homestead exemption provides constitutional protection against MERP recovery without any deed required. California's 2024 Medi-Cal reform significantly limited estate recovery to probate assets, making a revocable trust or TOD deed in California highly effective. Ohio's MERP recovery extends to certain non-probate transfers, making Ohio one of the most challenging states for TOD deed protection. For states where the TOD deed does not fully protect the home, or for families who want the strongest available protection for a home that represents a significant portion of the estate, the Irrevocable Medicaid Asset Protection Trust is the gold standard. The architecture: the homeowner transfers the house into the trust. The trust owns it. The homeowner retains a lifetime right to occupy the property. Because the homeowner gave up legal ownership, Medicaid counts the transfer as a disqualifying gift, and the 5-year look-back clock starts. If the homeowner survives 5 years without needing Medicaid nursing home benefits, the house is fully protected. It passes to the trust beneficiaries at death, outside of probate, beyond MERP's reach, with a stepped-up basis under current IRS rules. For Helen, this ship has sailed. She did not fund an IMAPT before her diagnosis. She did not start the 5-year clock. Even if Carol could execute the trust today using the 2019 POA, which is legally doubtful given the capacity questions, the 5-year look-back window would not close until 2030, by which time Helen will almost certainly be on Medicaid. But for you, watching this bulletin in June 2026 with a parent who is 72 or 75 or 78 and currently healthy, that clock can start today. Every month of delay is 1 month added to the back end of the risk window. The family that funds the IMAPT in 2026 for a 72-year-old parent closes the window in 2031. The family that waits for a symptom closes a window that may already be gone. State nuance. In Massachusetts, the IMAPT is particularly critical because Massachusetts MERP recovery extends beyond the probate estate to include certain trust assets, but a properly structured IMAPT with the look-back window fully elapsed is protected even in Massachusetts. In New Jersey, where the Medicaid asset rules are among the most aggressive in the country, the IMAPT combined with a Medicaid-compliant annuity for the community spend down creates the most comprehensive available protection. In Virginia, the IMAPT and the TOD deed are complementary. The TOD deed is simpler and faster. The IMAPT provides deeper protection for higher value homes. Helen is past the 5-year window for the house, but she is not past the window for her liquid assets, the $310,000 IRA and $44,000 savings account that are funding her private pay period. At the point when those assets are nearly depleted and Medicaid eligibility approaches, a Medicaid-compliant single-premium immediate annuity can convert remaining countable assets into a non-countable income stream, accelerating Medicaid eligibility and reducing the total spend down. Here is the mechanics. As Helen approaches the Medicaid asset threshold, $2,000 in Virginia, Carol uses the remaining countable funds to purchase a Medicaid-compliant SPIA. The annuity must be irrevocable, non-assignable, actuarially sound for Helen's life expectancy, payable in equal monthly installments, and name the state as remainder beneficiary after Helen. When structured correctly under Virginia DMAS regulations, the annuity converts a lump sum countable asset into a non-countable income stream. Helen qualifies for Medicaid. The annuity income pays toward her patient liability, her share of nursing home costs, and DMAS covers the balance. The SPIA does not protect the principal from spend down. It is the spend down, converted into a structured form, but it protects against the worst-case scenario, running out of money entirely before death, leaving the estate with only the house and a maximum MERP claim. The SPIA can extend the income stream, reduce the MERP eligible period, and create a more orderly transition to Medicaid coverage. State nuance. Virginia DMAS regulations governing Medicaid-compliant annuities are codified in 12 VAC 30-40-292. Virginia requires the state to be named as primary beneficiary up to the amount of Medicaid benefits paid. Some states, Georgia and Missouri in particular, have challenged SPIA strategies in administrative proceedings, and the rules are actively litigated. In Florida, SPIA strategies are well established and have strong case law support. Always engage an elder law attorney with specific state Medicaid experience before purchasing any annuity for Medicaid planning purposes. The product must be DMAS compliant, not just actuarially sound. Here is the instrument that most families never know exists until they are standing in front of a DMAS recovery demand for $295,000 on a house worth $387,000. Every state's Medicaid program, under federal statute, is required to offer an undue hardship waiver process that allows the estate to contest the recovery claim on hardship grounds. The federal guidelines under the State Medicaid Manual section 3810.d specify the minimum hardship criteria states must recognize. The asset subject to recovery must be the sole income-producing asset of the heir, or the heir's primary residence, and the recovery would deprive the heir of a minimum level of subsistence. Virginia's undue hardship waiver process is administered through DMAS and requires a formal application, documentation of the heir's financial situation, and a showing that the recovery would create genuine hardship. The waiver is not guaranteed. Virginia grants it selectively, but it is the only instrument available after the fact, after Medicaid has been paying, after the look-back window is closed, after the TOD deed was never executed. For Carol, whose financial situation may meet the hardship criteria if she has modest income and no substantial assets of her own, the waiver application is the last remaining lever. The waiver application requires an elder law attorney who has filed them before in Virginia. It requires documentation. It requires knowledge of the Virginia DMAS appeals process. It is not a DIY instrument, but it exists, and families who do not know it exists forfeit the only remaining protection without ever attempting to use it. State nuance. California's 2024 Medi-Cal reform eliminated estate recovery for most non-institutional care recipients and significantly narrowed the hardship waiver criteria needed for institutional care. California waiver applicants now face a substantially easier standard than they did 2 years ago. In Ohio, the hardship waiver process is more restrictive. Ohio has historically applied the hardship criteria narrowly, and the grant rate for Ohio hardship waivers is lower than the national average. In Florida, the homestead exemption renders the hardship waiver mostly moot for the primary residence. Florida does not pursue MERP recovery against the homestead to begin with. Let me bring Helen back one final time. Helen Burrows is still alive. She is in the memory care facility in Richmond. Carol visits twice a week. She brings the same lavender hand cream her mother has used since 1987. Helen recognizes her daughter on most visits. On some she does not. The Cape Cod is being maintained by a neighbor who agreed to check on it weekly. Carol has not listed it. She cannot yet. Helen is still alive. But the clock is running. Every month Virginia Medicaid pays Helen's bill. The recovery claim grows. When Helen passes, Carol will have 60 days from the date of death to respond to DMAS's initial recovery notice. She does not know this. Nobody has told her. It is June 2026. If Helen had executed a transfer on death deed in 2022, when she was 74 and sharp and walking her 3-block loop every morning, the Cape Cod would already be protected. Zero cost to the estate plan. Zero impact on Helen's Medicaid eligibility. Zero MERP claim after death. Carol would inherit a house worth $387,000 with a stepped-up basis under IRS Publication 523, owing nothing to the Virginia Department of Medical Assistance Services, with the full value of Walter's and Helen's 43 years of mortgage payments intact. The document Helen needed was 2 pages. The attorney time was 45 minutes. The recording fee at the Richmond Circuit Court Clerk's office was $200. The cost of not having it, potentially $295,000. Your parents' home is either protected or it isn't. The protection is not automatic. It does not come with the deed. It does not come with the will. It does not come with the power of attorney, drafted in a general practice law office for $350. It comes from a deliberate decision, made while capacity exists, executed by an elder law attorney who knows the difference between a standard estate plan and a Medicaid protective estate plan. This channel publishes early warning bulletins within 48 hours of a state MERP policy change. A Virginia DMAS regulatory update, a federal CMS guidance document affecting estate recovery, a court ruling on TOD deed protection in Medicaid proceedings. When those changes happen, and they happen, you will hear about them here before the Elder Law Bar sends out its newsletter. Subscribe, hit the bell. The families who know about the transfer on death deed before the diagnosis are the ones who keep the house. Your sources are free and publicly available. Social Security Act, Section 1917B, the federal MERP mandate, is at ssa.gov. IRS Publication 523 governs the stepped-up basis rules that make the TOD deed and the IMAPT so powerful for capital gains purposes. It is at irs.gov. Virginia Code Section 64.2-621 through Section 64.2-639, the TOD deed statute, is at law.ellis.virginia.gov. Read all three, print them. Take them to your elder law attorney and ask, is my parents' home protected from MERP right now? Be Carol who called the elder law attorney while her mother was still walking that 3-block loop every morning. Don't be Carol who called after the neurologist wrote the word dementia in the file. I'll see you in the next bulletin.